Hey everyone, welcome back to our probate case study series. I'm Bobby Sawyer with Johannes Meyer and Sawyer. Today we're talking through a recent call I had this week about ancillary probate. That's when you have probate open in one state, in this case Kentucky, and then you have real estate in another state, in this case Alabama. Super common for families with vacation homes, beach properties, or inherited land that's out of state. If you or a client are an executor or an heir dealing with multi-state estates, stick around. This one will save you headaches and money. So quick disclaimer, like those scrolling down the bottom of the screen there. I most likely am not licensed in your state. I am not your attorney. So before acting on any advice or anything that issues that you're dealing with, please consult with an attorney licensed in your state. All right, so back into it. Ancillary probate. Probate open in Kentucky. We need to deal with property down in Alabama. So the client is the administrator of his mom's estate. He opened probate on February 11th up in Kentucky. This estate includes property in Gulf Shores, Alabama, Baldwin County. There's 3 brothers total. 2 want to keep the house, and they're buying the 3rd one out so they can keep the beach house in the family. All siblings are on the same page, which is good. No fights. If one brother didn't want to sell the property or there's infighting there, that severely complicates things and makes the probate process a lot more expensive. Mom had already put the client on her bank accounts, so that makes it easy for him to pay the bills, keep things moving along. Nothing urgent really, but they did want to wrap things up. So the core problem, why ancillary probate is needed. Bottom line, Kentucky probate courts have absolutely no jurisdiction over real estate that's in a different state. You can't just transfer the deed from the primary state. Alabama requires its own ancillary proceeding. And the extent of that proceeding is going to vary by state. Some states it can be relatively quick. Other states it can be more involved. Alabama happens to be one of those states where it's more involved. Key facts. You must open the secondary or ancillary probate in the county where the property sits. You'll need to file exemplified copies of the will, or exemplified copies of the probate file from Kentucky. One thing to note with exemplified copies, they typically show up stapled together. Do not remove the staples under any circumstances. It invalidates the exemplified copies, and then you have to go through the whole process, spend the money for another exemplified copies, and delay getting ancillary probate open. The court appoints the personal representative, so usually the same person from the primary state. And then this triggers Alabama's 6-month creditor period once the ancillary probate is open. And this period is so if there's anyone, or if the decedent, the person who passed away, his mom, owed money to anyone in the state of Alabama, they can file a claim against the state or the estate, potentially resulting in the property having to be sold to satisfy the claim. Hopefully that doesn't happen in this case. Here's some questions he had and how he answered them. And I forgot to add to the disclaimer, all identifying details have been removed to maintain attorney-client privilege. So don't worry about anything along those lines. He asked, do I need an Alabama attorney, or I can handle it myself since I'm already an administrator? My response, yes, he could handle it himself. However, he's 8 hours away, and local counsel makes the court much more cooperative. Clerks and judges simply prefer working with Alabama licensed attorneys because they're much more familiar with the process and they don't have to worry about getting legal advice or having to explain things to non-attorneys. He asked about timeline. How soon can we get the 6-month clock running? We explained since there's no rush on their end, but it's better to get the ball rolling simply because it frees up the deed transfer earlier. It's not out there pending. He's not stressing about it, and you can wrap things up sooner rather than later. Oh, and I meant to say, if you have a specific question about this, please drop it in the comments. Be happy to respond there. He asked about scope. Does this just appoint me as administrator, or does it cover the buyout deed later? It's a very good question because typically if you open ancillary probate and then come back later and say, oh, by the way, I need to transfer this property, or we want to buy out my brother, you may incur additional fees. We're a one-stop shop. We quoted him one flat fee. We handle the probate, prepare the deed transfer, and he and his brother can start enjoying the property there in Gulf Shores. Our solution, what happens next? We spoke about the price. We sent him an engagement agreement and invoice so he can review with his brothers. Once they sign it, we'll get the ball rolling, file the ancillary probate, and file the ancillary petition in Baldwin County, Alabama, get the client reappointed as personal representative, start the 6-month creditor period, and after that, prepare and record the deed transferring the property from all 3 of the brothers to 2 of the brothers. Because brothers are all on the same page, this process will be relatively smooth and painless for them. So, key takeaways and viewer tips. 3 big lessons from this call. Out-of-state real estate almost triggers ancillary probate. Plan for it early, particularly if you are planning on selling the property. Some states require additional steps. You may even have to get court approval depending on the circumstances in order to sell the property. The 6-month creditor period is a hard clock once you open it. Starting sooner is often better. And then local counsel and flat fee packages are ideal. You don't have to worry about getting nickel and dime every time you email or phone your attorney or paralegal. Look for flat fee pricing, particularly on something that's straightforward. And pro tip, if you're an executor right now and have property in another state, check the county probate website for ancillary requirements, and always run the creditor period in both states if needed. If this sounds like your situation, drop a comment or DM. Happy to help you point to resources, not real advice. And also, you got our email scrolling across the bottom there, hello@jnspllc.com, and our phone number 803-266-9910. So that's today's case study. We'll be doing these on a regular basis. Next time we'll have there's also some interesting ones out there, like contested will, trust funding issues. Hit like, subscribe, follow so that you can follow when we go live. We'll also be posting this on our YouTube channel and across our various social media platforms. So this is not legal advice. This is for educational purpose only, and make sure you work with an attorney licensed in your state. So again, I'm Bobby Sawyer with Johannes Meyer and Sawyer. Hope this has been helpful and educational for you, and look forward to the next stream. Have a good day.